From Victoria, BC, and indeed right now it is my pleasure to call on Premier Brian Peckford of Newfoundland, who helped negotiate the Charter of Rights, to talk about that Charter of Rights. It's the thought experiment come true. Premier, great to see you again. I say all that because you are a historical resource. You're not just a pundit. You are a man who was part of Canadian history, and we're very glad to be able to talk to you.
Thank you very much. It's great to be on with you again, Ezra.
Well, thank you. And I want to take our time because our viewers love not just the education they get from you, but the passion. You are a true believer in this country, and you're in British Columbia now. You, of course, are a Newfoundlander at heart. And I think you people can tell your love for this country, and they're moved by it. I'd like to talk about a couple things. Like I say, you're not just an observer or a pundit. You're a man of history. You're part of history. And you were the plaintiff in a constitutional challenge to the federal government's rule that banned unvaccinated people from flying or taking the train. Now, unfortunately, the court saw fit to throw that out, saying it was moot. I understand that you and your fellow plaintiffs, including Maxime Bernier, have filed an appeal. Can you tell us a little bit about the legal status of your lawsuit? I think it's important that it get its day in court. Tell me a little bit about your thoughts.
Yes, well, when we lost in the federal court on the idea of mootness that the judge ruled on, we and the lawyers took a hard look at this to see whether there were grounds for appeal. And the lawyers came back and said, in their view, and in my view too, there is a strong argument to appeal. And so we have filed the appeal now, and we're waiting for the federal government, for the Crown, to respond to our appeal application. And so that's where we are right now. Hopefully we'll get a federal government response to our appeal, and then a judge will be appointed, the Federal Court of Appeal, to hear our appeal and then give us a date. So that's where it is. Very interesting, Ezra, your viewers might like to know that a court in British Columbia, since this COVID business started, ruled against moot being used in this constitutional pandemic environment, because the judge said that we don't know when this is all going to be over, when they're going to perhaps reinstitute it again. Of course, that was one of our arguments before the federal court, that this is not a moot at all, because the Minister of Transportation and other members of the federal government had indicated that they would bring this back in again at a moment's notice if they felt, in their wisdom, in my view, in their own wisdom, that it was needed. So it is not a moot, dead situation. It's a very alive situation. The other argument we're making now in our appeal is one that's very, very important, and that is, this is in the public interest. There were millions of Canadians who were unvaccinated, who were denied their constitutional charter rights to travel, to see their parents, to see their family, to visit their business, whatever, or even travel outside the country to friends or family. And so our constitutional rights and freedoms under the Charter were violated, millions of Canadians, and that this is in the public interest for the highest courts in the land to adjudicate on the federal government's action and whether it's constitutional or not. So those are our two main arguments. The third one, which is sort of secondary, but when you hear it, it makes people really mad, and that is that the judge talked about not being able to afford the time. This really wasn't, a case now because it's moved to take up the time of the court and the cost of the court. This from a judiciary, which is involved with a government that has spent like drunken sailors over the billions of dollars in the last 3 years. So it's a pretty silly argument, and hopefully the lawyers will get a chance to argue that in court as well. So those are the three main things. Yeah. And so we're waiting now to see when the federal government responds to our application of appeal and a date for when it will be heard.
Right. Well, I'm very glad you are doing that appeal. And I presume it's with The Justice Center for Constitutional Freedoms, well, they're excellent, and we know them, and they really do set the standard. And I'm a supporter of theirs, as well as the Democracy Fund, two great civil liberties groups. There's a circular argument to saying, well, we ought not to take up the court's time with this travel ban because it's gone. Well, the thing is, I don't know if the phrase is a circular argument, but if it's in place for a number of months or let's say even a year, if the court moves slowly, which is the court's way, and then the government removes the flight ban, if you could not possibly have been in court any faster, if they move so slowly, we'll never know if it was legal or not. And they could bring it back and then take it out and bring it back. And I suppose theoretically, technically, they could, every year they could suspend it and say, oh, you can't take us to court because it's moot. I mean, just because the courts are slow doesn't mean it's not an important matter. And the government has not repudiated it or renounced this. As you say, they would do it again in a flash. They thought it was very good. And I can't think of something that's more in the public interest to more people than this.
Yeah, absolutely, Ezra, and you make an excellent point. Because guess what? We applied for this to be an expedited case, and the courts accepted it, and the federal government accepted it as an expedited case. Then they turn around after agreeing to speed it up and slow it down by going back to the court and asking for changes as to how many people they would have arguing the case 2 or 3 times. And so they are the people who have contributed to us not having the case heard before the federal government took away the mandates.
Yeah, I think their very slowness, it's on them. And then for them to say,
yes,
oh, too late, you're out of time. Well, listen, I wish you good luck with that. And it sounds like there are many steps yet to go. But do you think there's a chance that the appeal could be heard in 2023, or do you think this is something that won't be heard until next year? I mean, boy, these courts move slowly, don't they?
Oh, man, it's just unbelievable. When you look at some of the appeal courts in the United States and compare it to here, it really makes you sad. But no, our best judgment and talking to the lawyers and so on is that it will be heard this year.
I'm glad to hear it. You're right to point to the United States. I mean, the Supreme Court itself in the United States weighed in on various lockdown rules in, I think, as soon as 2020. I mean, there were some great cases written, and the Supreme Court of the United States has some brilliant writing. I mean, their judgments really come alive, and they're often quite brief, which is the best. Like there was a famous case, Gavin Newsom, the governor of California, locked down churches, but gave exemptions to some Hollywood productions. And I forget which judge it was who said, if you can sing at America's Got Talent, you can sing in a church. He wasn't saying you can't lock down a church. He was saying you can't lock it down any harder than the governor. And that was one of the things the governor said. You can't go to church because there's all this singing. And the court said, well, if you can allow, it was just a beautiful short ruling that said, if you can sing on America's Got Talent or American Idol, you can sing in a church. And they quickly swatted down these unconstitutional moves. And in Canada, our Supreme Court has yet to weigh in on any lockdown or pandemic matters. Our Supreme Court has literally not ruled on a single case. Am I right on that, Premier?
Yes, exactly. You're absolutely right on that. It's an embarrassment to Canadians to think that these courts in Canada can move so slowly, and here our neighbor to the south can move so much quicker. I mean, what can you say anymore about the way the court? And the other thing about this case now, as I said in my introduction, is that there was a court in BC, in the Supreme Court of BC, which actually said that the mootness argument was not valid. So you have one court, a high court in one province, saying moot is not valid in this pandemic era. You need decisions, you need answers. And then another court at the federal level saying that you can use mootness. So the judiciary has a problem in being consistent.
That was an excerpt from the Ezra Levant Show. I'm Ezra Levant. Every weekday, I do a monologue about the topic of the day. Then I interview a fascinating guest either in studio or via Skype. And then I read your mail, whether it's fan mail or hate mail, which is sometimes even more interesting. This is on our premium service, though, called Rebel News Plus. Go to rebelnewsplus.com. It's $8 a month or less if you buy a whole year in advance. You get my show every weeknight, plus Sheila Gunn Reid's show every week. It's called The Gun Show. It's pretty amazing. You know, we rely on you because we do not take a dime from the government. In Canada, that makes us almost unique. So please help us out and help yourself to some great journalism at rebelnewsplus.com.